Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today's the day I earned that subscription. For today's story, we are dealing with the Respect for Marriage Act, a bill that was just signed into law by President Biden. And this bill changes some definitions in federal law with respect to marriage. It's gotten a lot of press. A lot of people have talked about it, but not a lot of people have actually talked about the bill itself. Well, that's what I'm going to do. We're actually just going to read the bill. We're going to show you exactly what it does and what it doesn't do so that we're all better informed. Let's get started with this. Okay, so this is the actual text of the Respect for Marriage Act that has been created by law into federal law. Congress makes some findings. Congress finds that no union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. How nice. Diverse beliefs about the role of gender in marriage are held by reasonable and sincere people based on decent and honorable religious or philosophical premises. Therefore, Congress affirms that such people and their diverse beliefs are due proper respect. That's kind of nice. Millions of people, including interracial and same-sex couples, have entered into marriages, having enjoyed the rights and privileges associated with marriage. Couples joining into marriage deserve to have the dignity, stability, and ongoing protection that marriage affords to family and children. Okay, so that's just some fluffy words that Congress would like to share with you about how they feel about marriage and what it does or whatever. So the first thing is that the Defense of Marriage Act is just repealed. So we repeal that. And we replace some stuff with this. All right, certain acts, records, and proceedings thereof. All right, so this is what we're actually amending the law to do. No person acting under color of state law may deny. Okay, so no person acting under a state authority may do this. May deny full faith and credit to any public act, record, or judicial proceeding of any other state pertaining to marriage between two individuals on the basis of sex, race, ethnicity, or national origin of those individuals. Which, fair enough as far as it goes. Full faith and credit is part of the Constitution anyway. Every state is required to give full faith and credit to the judicial determinations of every other state, and weddings are a legal proceeding. So the Congress saying, okay, the states have to give full faith and credit is kind of saying the obvious in some respect, because they kind of already had to do that anyway. But so they now have a basis in a federal statute as well as federal constitutional law. So that's a little bit just repetitive, but okay. We have to give full faith and credit, but we kind of had to do that anyway. What else can't we do? Well, we can't deny a right or claim arising from such a marriage on the basis that such marriage would not be recognized under the law of that state on the basis of sex, race, ethnicity, or national origin. So even if that particular state does not recognize those kinds of marriages as a matter of its own state law, it has to recognize the marriages performed by other states, but it doesn't necessarily have to do it by its own state law, right? So the United States Supreme Court, for example, in Obergefell, says that same-sex marriage is a constitutional right, but this, of course, is a federal protection in statute, and it doesn't need to go as far as the Constitution does, right? The Constitution obviously protects more, right? So if the federal statute can protect less, the Constitution is obviously going to win out over a statute. But the idea here is that in the unlikely event that Obergefell was ever overturned, right, and you no longer had a constitutional right to marriage, or same-sex marriage, you would still have some sort of statutory right. So this is maybe a backup. This is a backup that is, so in the event that Obergefell ever gets overturned, this would be the operative law. But until that happens, Obergefell is the operative law. But that's what they're talking about there, right? So a state, even if they wouldn't recognize those kinds of marriages as a matter of its own state law, would have to recognize it anyway as a matter of this federal law. Okay, fine. The Attorney General may bring civil action against any person who violates this for declaratory or injunctive relief. Okay. Any person who's harmed by a violation of this may bring a civil action in appropriate district court for violation. So you give a private right of action as well in federal district court to affirm federal statutory rights. And then state has the definition the state typically does, although they'll define it more. So far, kind of so good, right? This basically says this by its own terms does not require any state to perform any kind of wedding. So this bill, in some senses, is not as expansive as maybe has been reported, because it doesn't require any particular state to perform any kind of particular wedding. What it does say is that if a state does perform a wedding on these kinds of bases, another state has to give that full faith and credit, which is implied by the Constitution anyway, and can't deny benefits even if they wouldn't grant the marriages of their own right. So this would allow people to fly to one state, get married, and be recognized in their own state, even if their own state would not perform those weddings as a matter of its own state choice. So that's kind of what it's talking about. Then we go on to define what marriage is. For the purpose of any federal law, rule, or regulation in which marital status is a factor, an individual shall be considered married if the individual's marriage is between two individuals and is valid in a state where the marriage was entered into, or in the case of marriage entered into outside of any state, if the marriage is between two individuals and is valid in the place where entered into, and the marriage could have been entered into a state. So if it occurs within any of the United States, then the question is, was it valid in that state? If so, then federal law considers it valid, which kind of was true anyway. And again, also for respect to outside the United States, if you have a destination wedding, as long as it could have been conducted within any states, the federal government will recognize that too, which is kind of also per normal. The term state means any state, District of Columbia, Commonwealth of Puerto Rico, or a territory or possession of the United States, which is pretty typical. For the purposes of this subsection, in determining whether a marriage is valid in a state or the place where it is entered into, if outside any state, only the law of the jurisdiction applicable at the time of the marriage was entered into may be considered. So, rather than looking to every jurisdiction that is in play, we can only look into the jurisdiction where the law where occurred, right? So we don't have to worry about our choice of law problems. But again, this is pretty par normal, right? As long as you're conducting a valid wedding that's occurring valid somewhere, and it could occur within any state, the federal government will recognize it. But again, this is fairly typical for most states. So nothing really there in major. Then there's Section 6, which says there's no impact on religious liberty and conscience. In Section A, saying nothing in this act or any amendment made by this act, because this law amends other provisions, right? Because you've seen where they're making changes to other provisions of law. So they're saying that nothing this act does, or any amendment made to any other act that this law does, shall be construed to diminish or abrogate religious liberty or conscience protection otherwise available to an individual organization under the Constitution of the United States of America. Consistent with the First Amendment to the Constitution, nonprofit religious organizations, including churches, mosques, synagogues, temples, non-denominational ministries, interdenominational and ecumenical organizations, mission organizations, faith-based social entities, religious educational institutions, and nonprofit entities whose principal purpose is study, practice, or advancement of religion, and any employee of such organization, shall not be required to provide services, accommodations, advantage, facilities, good or privileges for the solemnization or celebration of that marriage. Any refusal under this subsection provides subservice shall not create a claim or cause of action under these titles. Now, it's important to note here that that doesn't necessarily mean that you don't have a claim somewhere else, right? This law is simply saying that there's no claim here. So this law is saying that, well, at least as far as it seems to be reading, that they are not required to provide any services for the solemnization or celebration of marriage. Now, what exactly that means is questionable, but that extends to churches and religious institutions. It does not, by its own terms, extend to non-religious institutions or cake makers, for example. And it also doesn't mean there might not be some other cause of action somewhere else, but there's no cause of action here for that kind of thing. And then there's a nice little clause here that just says nothing in this act or any amendment made by this act shall be construed to deny or alter any benefit, status, or right of otherwise eligible person which does not arise from marriage, including tax-exempt status, tax treatment, educational funding or grant, contract, amendment, guaranteed loan, scholarship, or other defense. So nothing there. And just in case there was any sort of ambiguity about the whole thing, Nothing in this act or any amendment made by this act shall be construed to require or authorize federal recognition of a marriage between more than two individuals. So polygamy, at least for the moment, well, not necessarily illegal, but the federal government won't recognize it, at least under this act. And then there's a little severability clause that just basically says if anything's unconstitutional or invalid, then nothing else is affected, which again is very, very typical. So I hope that helps you understand a little bit more about what the Respect for Marriage Act does and does not do. So in some ways, it is a very modest thing. It requires states to recognize marriages performed by other states. And in some ways, that's all it does, which in some ways was required by the Constitution anyway, because of the Constitution's full faith and credit clause. But this basically is just a stopgap that says that in the event, this basically is all meant to be in the event that for some reason Obergefell is struck down, that all those marriages remain valid, and states can still choose what marriages they do and do not allow as a matter of their own state law, which has been true. It only is a slight deviation in that it extends those protections explicitly to make other states recognize the validity of those marriages, but does not require them to perform themselves. So in a lot of ways, this is somewhat of a nothing burger. It's something of a very mild and modest thing. It doesn't really require, and it certainly, by its own terms, does not require any religious organization to do anything that would recognize or affirm marriage and grants all those religious rights as well. So there's not really a lot in here that is really majorly concerning, especially because what the U.S. Supreme Court placed in Obergefell requires more than this federal statute does. So Obergefell is the dominant law over this because Constitution beats statute, and Obergefell was a constitutional decision. So this really, in a lot of respects, doesn't do anything at the moment because Obergefell is a superior authority. But this is all meant as some sort of stopgap, or maybe it's meant as a virtue showing exercise. But either way, it's a little bit neither here nor there. But I hope you know a little bit more about this Respect for Marriage Act, what it does not do, what it does do, and that brings us to the end discussion of this story.